The court is reconvened after technical difficulties. Mr. Goodfellow, please continue.
My lords, my ladies, it's also worth noting that the follower notice legislation didn't alter the substantive rights of the participants to the tax arrangements. They had just as much chance of winning before and after the legislation as before. So in no way, this isn't a case of Parliament cutting down rights, substantive rights. So they had just as much chance of winning. So the idea that the legislation is targeted at particular users of schemes is erroneous, or particular activity. It's targeted at people who are participants of tax arrangements which have been shown to fail. And that is the object of the legislation, not to discourage particular behaviour. It's to discourage, well, in the generality, it's to discourage people carrying on after they've been told about decisions which showed that their arrangements failed. The principle of legality is clearly engaged here. The case of Unison shows that impediments to access to justice, one, have to be authorised by clear words, and even if, when they are authorised to some degree, they aren't to be treated as interfering with the right to access any more than is reasonably necessary for the to achieve the objective of the legislation. And so that's why in Unison, whilst it was accepted that it was part of Sections 42's legitimate purpose, both to raise money by charging fees and to deter vexatious litigation. That wasn't the end of the inquiry. The court read down Section 42 so that it didn't authorise secondary legislation, the fees order, or secondary action, if you're looking at the issue of a follower notice, which went any more than was necessary to achieve the objective. The objective here is, as I've said, and so the principle of legality in our submission is highly relevant to determining the scope of the discretion conferred upon the revenue under Section 204. It mustn't be to do anything more than deter taxpayers whose arrangements have been shown to fail by the principles or reasoning. It isn't to deter people who retain an arguable case. And again, if one looks at paragraph 29 of Unison, Lord Reid accepts that litigants who have arguable cases have the right of access to the courts, even if they lose at the end of the day, as long as it's got an arguable case. And secondly, at paragraph 28, Lord Reid acknowledges that employment litigation is often complex and hard to predict. And in a way, that's a clear answer to my learned friend's point that, oh, of course, taxpayer has perfect knowledge of all facts relevant to his case. I mean, it's a highly complex tax, probably by a factor of 10, is highly complicated. And secondly, the taxpayer will not have perfect knowledge of all relevant events. I mean, this case is an example. The charge is on the set law, but a major factor in determining where the high level management decisions were being made will be by reference, and the ability to show that will be determined by reference to the evidence and habits and record keeping of the trustees. If the trustees can show that they were conscientious and scrupulous in their decision making and merely took advice, then that's going to be a strong case. If not, if they're just falling into line, then that isn't. But that's going to be a weaker case, but that's not going to be known by the settlor in all circumstances. Moving on, the function of the principal view of legality, and this is paragraph 65, is to read the legislation by reference to that principle of interpretation as enunciated in unison. And so many of my learned friends' points about what language might have been put in misses the point. The whole point of the principle of legality is it recognizes that in the hubbub of the parliamentary process, the full implications of general words may be missed. And that the point of the principle of interpretation, whilst recognizing parliamentary sovereignty, is to make sure that absent clear words, express words or necessary implication, one doesn't read down or one doesn't interfere more than is necessary with fundamental right. The case of Locke is an important case. This is at page 880, Appeals Bundle 1, tab 6. As Court of Appeal decision in Locke clearly shows, it's vital to analyse carefully to decide what the judicial ruling did decide and what it didn't decide. And that is a matter of judicial analysis. It's not a matter of discretion for the revenue. And you can see, without delving into the facts of Locke, it's that you had a film partnership. The judicial ruling relied upon was Eclipse number 35. It was a film partnership. It went all the way up to the Court of Appeal. The Court of Appeal held the film partnership wasn't trading. It was carrying on an investing activity. The taxpayers in Eclipse 35 had entered into the same documentation as Mr. Locke, the taxpayer, who was a member of the partnership in Eclipse 10. Their claim in Eclipse 35 for interest relief was on the basis that they'd used the borrowed monies to advance capital to the partnership. And in that case, under section 362(1)(b), they had to show that the partnership used it for the purposes of the trade being carried on. And Eclipse 35 decided that the partnership wasn't carrying on a trade. Mr. Locke claimed his interest relief on the basis that he'd used the borrowed monies to purchase an interest in a partnership. If that was right, he didn't have to show that the partnership was carrying on a trade. The follower notice was issued on the basis that Eclipse 35 denied his relief. As I said, the documentation by which the money, to use a neutral term, was advanced or paid over to the partnership by Mr. Locke was materially the same as in Eclipse 35. And the whole case of Eclipse 35, it was an assumption that the only basis on which the taxpayers could get interest relief was by showing that the partnership was trading. But it was never argued that what the taxpayers in Eclipse 35 had done was purchase an interest in the partnership. The revenue said to Mr. Locke, Eclipse 35 doesn't determines your claim for interest relief. The Court of Appeal quashed the follower notice on the basis that it wasn't a matter of comparing the similarities of the two arrangements. It was a question of identifying what was the legal issue in dispute in the judicial ruling and to seeing what it had to say about the arrangements, how decisive it was in relation to the arrangements being carried on by the recipient of the follower notice. And the short point was Eclipse 35 had not decided that the advance of monies could only be characterized as an advance of capital and not as a purchase of the partnership interest. So it was a short point that the issue had not been decided by the court by Eclipse 35. The learned judge, Mr. Justice Lewis, in the finding of the Court of Appeal, had erred because he'd asked the wrong question. He'd asked, are the arrangements similar? Of course they were, but the documentation was exactly the same, or material exactly the same, and the business model was exactly the same. But Section 204 didn't, the discretion in the opinion of, did not authorize the revenue to skip over a close analysis of what the case did decide. And it hadn't decided that point. And we rely on paragraphs 49 through to 54 of Lady Justice Richard's decision. One is confirm the authority that the scope of these powers, given their draconian nature and the capacity to interfere with access to the courts, they should be read down or read narrowly. And secondly, there isn't a discretion conferred on the revenue to decide what the principles or reasoning of the judicial ruling is. That's a question of analysis for the courts. It's something that the court, on a judicial review, is well able to perform. Lord Legate.
Well, do you take issue with Mr. Justice Cranston's analysis of what Smallwood decided?
Yes. We say what Smallwood decided was that there is no more than it being conceded that there had been a misdirection as to the test to be applied, i.e., we were looking at where the high-level management decisions were made and applying the commentary to the OECD, the OECD commentary, and that was normally where the authorized decision-making body met, in that case the trustees, but all relevant factors should be looked at. That was common ground. All that Lord Justice Hughes decided, well, there are two things. There's paragraph 70, where he expressly bases himself on the primary facts. I don't think it's possible to say that they weren't entitled to find that Perm was in the UK. He's clearly applying the second limb of Edwards and Bairstow. The first limb being, if you can find an express misdirection of law, you can interfere. The appellate court can interfere. But where the first instance court has set itself the right test, in relation to a mixed question of fact and law, or question of fact, you can only interfere if the true and only reasonable conclusion from the facts found is that is contrary to what the tribunal has actually found. And in those circumstances, you're forced to the conclusion they must have erred in law in the application of the legislative test.
But the key point, surely, that Smallwood decides is that you don't just look at the decision to sell the shares has a decision to sell shares on a particular day at a particular time, which may well have been taken by the. You look at the thing as a whole. And when you apply that principle to this case, there's only one answer, isn't there?
Well, no, that's.
I mean, there wasn't any chance at all that the Mauritian trustees were going to decide we're not going to dispose of the shares at all.
Well,
that was vanishingly, infinitely small.
No, with respect, well, I think it's important. Can I first? I'll deal with your lordship's point about Wood and Holden. If the court would turn to page 1135 of the bundle, this is Smallwood, and if you also have your finger in, or I don't know what the electronic equivalent is, at 1128, page 1128, which is paragraph 53 of Lord Justice Patton's judgment. On the relevance of Wood and Holden, he wasn't rejecting the reasoning of Wood and Holden. He was saying it doesn't apply solely by reference to the date on which of what is done on the date of disposal, because what he says it applies to the control of the trust during the relevant period, which was the term of the trust, which was during the Mauritian period, which was from December through to March 2000, December 2000 to March 2001. That was what he was deciding. That's what he decides, and that's because when you look at the Special Commissioner's decision and the relevant findings of fact are set out in Lord Justice Patton's judgment, and it's the findings of fact in paragraphs 136 to 145. What the special and it is, as Lord Justice Hughes says, on the primary facts, which the Special Commissioners found at paragraphs 136 to 145. What the Special Commissioners had decided was that the decision to sell the trustees' shareholding had been made in the UK as part of the arrangements by which the Mauritian trustees were appointed. And that continued throughout the Mauritian period, that sort of control. But in other words, the major decision as a do we sell these shares, what proportion, what price or whatever, that had all been made. That decision had been made. And that high level, that was the major function of the trustees, that had been usurped. All that remained, all that was left to the trustees was to decide which day within the designated period they were to sell, and to respond to certain remote contingencies. And if you look if you go back to page 1129, this is I'm going to take you to paragraph 140, but an important factual point here is the major asset of the trust was the first group shareholders. You can see from paragraph 138, Mr. Smallwood had retired as chairman. He was free of restrictions on selling. He'd originally the trust had originally acquired this shareholding as a share-for-share exchange for Badgerline, which was the family company. And so and first group was a quoted shareholding. So in other words, Mr. Small wanted out. There was a liquid market for the first group shares. At paragraph 140, you see this is letter F on page 617 of the report. The facts, this is a finding of fact by the Special Commissioners, the facts surrounding the appointment of PAMIL, that's the Mauritian trustee, lead us to the view that the real top level of management or realistic positive management of the trust remained in the UK. We accept that the administration of the trust moved to Mauritius, but in our view, the key decisions were made in the UK. You can see this is 141. They set out the events, but one of the points you will see in the third sentence, it had been carefully arranged beforehand by the transfer to Quilter, that's the stockbroker, to be held in their nominee account. So the shares in first group, which were held by the Jersey trustees, had been put into the nominee account of the UK stockbrokers in preparation for sale. And again, the Mauritian trustee who gave evidence, he accepted that the whole purpose of the exercise was to save tax, and that the tax needed the assets, the shares, to be sold by the end of March.
But that's self-evident in any of these schemes, isn't it?
No,
I mean, you don't send it off to Mauritius in order just for fun.
No, but
you send it off there so they can sell the shares and you can make free of capital gains. That's the whole point of the exercise.
Yes, but if
the only reason for doing it.
But with respect, my lord, if the events are uncertain and to occur, and here this is the important distinguishing feature. This trust was a minority shareholding in Tellyware. The value was to be created by a merger with Workplace and a subsequent flotation of the new holding company's Teleworks share on the stock exchange, all of which was completely contingent and uncertain, because you may recall that by 2000, the technology bubble had begun to burst, and on the facts of this case, the prior flotation had been pulled. There was a whole lot of different contingencies that happened. It wasn't.
I can't see why that's relevant. That just shows there might not have been any transaction at all. But if there is one, then you want to sell the shares.
If there hasn't been any transaction at all, they would have stayed in Mauritius, and there was a lot more decision making for the trustees to make, and which they made. And this is where the importance of Wood and Holden is relevant. But can I just carry on with it's important to appreciate the facts found by the special commissioners, which was the subject of the Edwards and Bairstow review, because that indicates what the judge, Lord Justice Hughes, was actually saying. If you see at paragraph 143 of the special commissioner's decision, which is set out at page 1130, we fully accept that the decision to sell the shares that day was taken by the directors of PIMIL at the telephone meeting on the 10th of January 2001. We also accept that if, for example, the price of the shares had fallen to a level that meant no gain would be realized on their disposal, the shares would not have been sold, but would have been retained. Nevertheless, in our view, this was a lower level decision, as there was no doubt that the shares would be sold. The real top level decisions, the realistic positive decisions of the trust to dispose of all the shares in a tax efficient manner had already been and continued to be taken in the UK. So all that had been left on the facts found by the special commissioner, the big decision to sell had been taken in in the UK usurping the authority of the trust. All they were left with is they could sell on Thursday, provided the price didn't plummet. And what the special commissioner goes on to say, and he was basically saying, drawing that distinction, the high-level decision and the low-level decision. But where and what Lord Justice Hughes, if you go back to 68, paragraph 68, again, the opening sentence is important to look at carefully. If the question were perm of the particular trust company trustee for the time being at the moment of disposal, namely PMIL, then it may be that the reasoning in Wood and Holden would justify the conclusion that the commissioners fell into this kind of error. But he says, look, the issue is the perm of the trust during the Mauritian period. And so it wasn't, the Smith and Holden reasoning was applicable. It wasn't determinative, because on the facts found by the special commissioners, there clearly had been substantial usurpation. And you see that going back to paragraph 68 of Lord Justice Hughes, I agree that their findings do not go so far as findings that the functions of PMIL were wholly usurped, but they had been substantially usurped. The major asset of the trust, they hadn't decided what to do with it, what was to be done with it. That had been made by the set law in the UK. And so, and again, if one looks this case, the exact reasoning what has been decided in the High Court has been the subject of lengthy debate in front of the tax tribunal in the case of Liam Bunter, and paragraph 73, it's cited in our case. The president of the tax tribunal said, well, actually, Smallwood doesn't decide this case. It doesn't overrule Wood and Holden. All it said, and Wood and Holden remains good law, that advice to trustees or to a board of directors, in the confident, even if it's given in the confident expectation of that it would be followed, doesn't amount to taking away control from those trustees or that board of directors, as long as they decide what to do, whether they're going to do it or not. Wood and Holden wasn't a case of partial partial usurpation. If it had been, then it might be more arguable that Lord Justice Hughes was actually saying it doesn't apply. In Wood and Holden, there was no usurpation of the directors of the relevant subsidiary, but they did agree to proposals being put forward by the parent company. But those proposals were in the best interests of the subsidiary. The trustees, the board of directors, decided to adopt them. Central management and control was held to be to remain in Holland, and there was a secondary issue which wasn't necessary to deal with, because what the Court of Appeal had decided in Wood and Holden on the first issue, which was if the central management and control was also in the UK, which the Court of Appeal had decided wasn't the case, then you had to apply the tiebreaker provisions in Article 4.3 of the UK-Dutch Treaty. The Court of Appeal in Wood and Holden Lord Justice Chadwick said he couldn't see any material difference between the test for place of effective management and the test for central management and control. Both are focused on the high level decision making. Both focus on the on where the decision making organ meets. But of course, where the decision maker, the authorized decision maker, has been usurped, you can come to a different conclusion. Now, if Lord Justice Hughes was disagreeing with the Wood and Holden analysis, he would have said so. He was just saying it doesn't decide that the only true and reasonable view on the facts found is that term of this trust was in Mauritius, because on the proper analysis of what the Court of Appeal, what the Special Commissioners had found, the major decision had been taken away from the trust, and they'd just been given this, left with this minor residual discretion. And again, if you look at the commentary, it's clear, which is adopted by set out in Lord Justice Patton's agreement in judgment. The commentary indicates that you normally look where the decision-making organ meets. That's the starting point. Lady Arden, I'm sorry.
I was just actually going to try and simplify and summarize and see if I'd got the point right. What you're saying is Smallwood was incapable of forming the basis of a relevant ruling because it is decided on a fact-sensitive basis, namely that when you look at the majority's decision, it appears that they were not departing from Wood and Holden, but they were saying that this was a case where there was two levels, what there was on the facts as found by the Special Commission, two levels of management, and therefore they were entitled to reach what I assume is a relatively unusual conclusion, that the key control was not exercised by the trustees, the de jure trustees, but by people in the UK. Is that roughly where?
Yes, my lady, that's right. And so, the only gloss I'd put on that is that they decided, the Special Commissioner said, the decision to sell the shares, that's the important decision. Which day you do it, and if the only what is a minor decision. And that's what Lord Justice Hughes is saying. Well, look, there's nothing in Wood and Holden that says that all the big high-level decision is being made in the UK, but there's a small residual discretion left to the people in Mauritius.
That's a ministerial act to decide the day.
Yes.
And it means that this appeal is to decide what I suspect may have been a dispute for some time as to what Smallwood decided. There was no further appeal in Smallwood.
No, yes, I agree. We say it requires a close analysis of what was decided in Smallwood, which was merely that on the facts found, the conclusion of fact reached by the Special Commissioners was within the range of possible outcomes.
Yeah. But it was an unusual result.
Yes, in the sense that having heard the facts and the witnesses, the Special Commissioners decided that the big decision had been made in the UK. And in other words, the trustees had been usurped.
And is that the same test for companies as trustees?
Yes. Well, yes. But trustees are meant to make their own decision, not delegate absent or express authorization.
Well, that's true for companies, but we have a fairly well-known vehicle called the shadow director. I just wondered if you had shadow trustees, but you have de facto trustees.
De facto and de jure, de facto.
Thank you.
Yes, I'm sorry, Lord Stevens and Lord Leggett. I didn't. Lord Stevens.
I was just interested in page 333, which is your client's response to the notice, the follower notice. It sets out various matters, but just take one of them as an example, and that is C, where it's asserted that there was no doubt that the sale of shares would occur in Smallwood in the present, but in the present case, the uncertainties surrounding the flotation meant that in fact it was considered likely that the Merchant trustees would remain trustees for an extended period of time, and the appointment was made on that basis. Now, I don't know whether that fact is right or wrong, but could you help me as to whether or not the judge at first instance has really decided that issue and decided that there is absolutely no basis for that factual difference, or indeed D or E?
I don't think the judge did decide that. It brings me on to without this matter really becomes relevant when you look at section 31(2)(a), which has been raised for the first time in relation to this issue.
Yeah.
But what one needs to appreciate about the proceedings before the admin court. Case, the only evidence was given by Miss Tilling, and she said that she didn't carry out the analysis of the facts. She couldn't find any record of the conclusion. She couldn't remember discussing it with Mr. Smith. Mr. Smith carried out the review. The only evidence of what conclusion there was, or whatever review there had been, was Mr. Smith's tick book exercise in relation to the Smallwood hallmarks, the Smallwood pointers. He went. There were 9 out of 260 documents. He ticked 9 by reference to these hallmark procedures. So he made no comments or other in relation to draft witness statements supplied in 2006 by the trustees and other people to the effect that they'd made the relevant decisions. I'm sorry, Lord Leggett.
Yes, I'm not sure criticising the adequacy of the review is open to, because I think I might have ruled that out at an earlier stage.
Yes.
But following up on Lord Stevens' point,
Yes.
two very important paragraphs of the judgment, paragraphs 105 and 106, where the judge basically says, well, when you look at the documents in this case, it's absolutely obvious what was happening here. It was being run from the UK. And therefore, even if they didn't do a proper review, the fact is that if they had done one, they would highly likely have come to that conclusion.
Yes. There are 2 points. First of all, I'll just back up one question. First of all, it was never, before the admin court, the rationality of the decision wasn't in evidence, wasn't in dispute, because we hadn't been given permission. It was or the issue was, had there been a misdirection in what Smallwood decided? That was the, and in addition, there was ground 3A, which when we got the subject access request information, it looked like the WFGG had basically handed over the decision-making function to the compliance team. And when one looked at the incredibly thin results of the Smith review, it wasn't clear that they'd actually come to a conclusion. All we have in relation to the evidence of the factual conclusion reached by the revenue in relation to this fact-sensitive issue is the spreadsheet of Mr. Smith, or the revenue spreadsheet, with the right-hand column WFGG pointers, and all you have is against 9 ticks against a set of documents, and that's the only evidence of what review had been. And so, what was when you look at Mr. Justice Cranston's decision leading up to 105, it's all under the heading. This is paragraph 94, which is at page 200. It's all in relation to ground 3A, which is a very narrow ground, which was there had been an unauthorized delegation from the WFGG to the compliance team. Secondly, that either there had been no review or no conclusion, no concluded review that the hallmarks, the 7 hallmarks, had been satisfied. And that is, but all of that, as Lord Justice Newey pointed out, and if you go on to paragraph 104 of the learned judge's decision, this is at 202, in relation to the no review, no conclusion, he was invited to apply section 31(2)(a), and he says, well, even if Mr. Smith didn't reach a conclusion, if the revenue had carried out the review to a conclusion, they would have come to the same conclusion. But that's all on the premise that they haven't misdirected themselves as to what Smallwood decided. Because the judge decided that there was no misdirection, notwithstanding the obvious misdirection you can see in the submission. So I'll come on to another point about Lord Stevens.
I take the point that the judge carries out a review of the documents, but there's a inconvenient thing called evidence, where you assess people's credibility. So I was just interested in how that concept works in to the HMRC forming the necessary opinion, where there is a factual dispute that depends on credibility. Do they have to separately analyze the potential for it being incredible? One of the issues is whether reasoning includes factual reasonings. But an aspect of that might be that when you're looking at a factual reason, you have to give separate consideration to whether or not the explanations given by your client are in the least bit credible. And so I was just wondering whether a documentary review, leaving out of account credibility, is sufficient in a a factual dispute?
We would say no, because we say the whole point of the follower notice legislation is where a judicial ruling has shown that the case is going to, the arrangements fail. That the principles or reasoning determines the case. The test is meant to be a predictor of what's going to happen if this litigates, if this arrangement litigates. So it's suitable, the follower notice legislation, where the scheme, for want of a better word, depends on a particular construction of the legislation. If the legislation is construed one way, it wins. In other ways, it doesn't. There's no factual dispute involved, and that's why mass-marketed, uniformly documented schemes were the target. When it comes down to a question of fact, you can't say that the principles or reasonings are determinative, because it depends on the facts. It depends, in this circumstance, is who made the decisions on behalf of the trust. When, were the trustees taking instruction, or were they making up their own minds? That's a question of fact. And the 2 points to be made. If you fast forward a case to the tribunal, it's not the revenue can say to the tribunal, we think the facts are these, and you can only review our decision on the basis of irrationality. But the tribunal makes up its own mind about the facts. And so when the determinative nature of a decision depends on what facts are found, it's obviously unsuitable for a follower notice. And Lady Justice Rose dealt with this in Locke, where she said that the words "in the opinion" are to give the revenue discretion to deal with where the principles laid down by the court are determinative in relation to the case before them, but the taxpayer is saying, well, my case is slightly different. And let's say sometimes you national insurance avoidance schemes, you could avoid them if you provided a payment in kind, and the legislature cut down gradually different types of arrangements, and each time the promoters moved on to a different type of asset. But the common thing was the employees didn't want platinum sponge, so there were always arrangements to convert it into cash. And so those arrangements were found to be ineffective because effectively it was a provision of cash, which was subject to NIC. The discretion conferred on the revenue is to say, well, where the taxpayer just says, well, I didn't use platinum sponge, I used gold bars, but the arrangements by which they were converted into money was exactly the same. That's the small discretion. But whether the whole issue depends on has this set of trustees been usurped in its decision making, or who made the high level decisions in relation to this trust? That's an intensely factual, sensitive inquiry, and there was to say that the revenue conform to take non-determinative principles, which is really the right analysis of what Lord Justice Hughes was saying in paragraph 70. He was saying, look, it was open to them. You can't say that it was unreasonable for them to conclude that the high level perm was in the UK, given the Special Commissioner's findings that the big decision had been made in the UK. We're saying I can't infer that they've misapplied the test. That's not a non-determinative principle. And the revenue can't then say, well, we're going to assume that the facts of your case are this, this, and this. And therefore, the same result will be reached. Because that would be a massive erosion of the access to justice. And secondly, it's going to be a bad predictor of the outcome of the case. Because the FTT won't say, oh, well, we'll go along with whatever the revenue reasonably think. They'll say, I could listen to the evidence. So, yes, and I would make slightly the jury point. It's been a subject of, we've had the appeal. It's been a 10-day hearing with 10 witnesses of fact in July, and we're still waiting for the decision. So I think it's fair to say it's not straightforward. And it certainly, the test is not, was there a plan? That's not the test of where poem is. And in fact, if I can then quickly go to the actual decision-making documents, which we say are relevant. So what you have at, if you go to 311, oh, I'm sorry, no, I apologize. Can I take you to 315, 317? This is the November submission, 2015 submission, which under the streamlined procedure was put up to the WFGG each time that they were asked to approve a follower notice. Again, at 615, paragraph 615, top of the page, Court of Appeal in Smallwood found on the basis of the evidence that the need to ensure that the share sale took place during the Mauritius trusteeship, and then that the trustees took their place, that the tax saving was carried out as planned, meant that the perm of the trust was not in the UK, it was not Mauritius, necessarily in the UK, from where the instructions were taken. And then again, it's repeated at 618. Lord Justice Hughes giving the lead judgment on the question, but found that the perm was necessarily in the UK as the inevitable consequence of the tax scheme. So in other words, what the WFGG is approaching on the basis that it was a requirement of the scheme to make the scheme work, perm had to be in the UK. That was actually followed. It was a product. And even at 619, it was still as a result of the planned operation of the tax scheme. So that is, and then at 620, they give the 7 pointers. And again, you'll see is that advice from the solicitor's office is that the tribunal is likely to find similarly if the following facts are present. And what they've done, they then give a little checklist to the compliance team to say, if you can find these factors, then the case is going to be determinative. But what they looked for was they're just looking for similarity of the arrangement. It's also important to notice that they didn't actually ask the compliance team to look at the one thing which might have been relevant, which was, can you see that there was a higher level management decisions were being made in the UK, controlled in the UK? That's no part of the hallmarks test.
Is that not at least quite near to what's being identified at step D in paragraph 6.20? Carefully orchestrated.
Yeah, carefully orchestrated. But again, it is, I don't want to take, if you look at 141 of the Special Commissioner's decision, that is what Lord Justice Hughes, he's characterising the particular role of the advisors in the UK, for that they were telling them to do this, stopping. It was, in the course of 10 days, in the first 10 days of January, it was get on with the sale. No, stop the sale because we haven't completed the appointment of the trustees in Mauritius, and then 2 days later sell. That was the orchestration. But again, what's important from these passages is one, the clear misdirection as to what Lord Justice Hughes had decided, because there's nothing in paragraph 70 or 68 which suggests that in any way the inevitable consequence of the operation of the scheme that Perm was in the UK. It's massively overstating it, and nor did he actually accept, nor was he actually expressing his own view of the arrangements. And that was conceded by Mr. Brennan before the Court of Appeal. But all he was saying is it was within the range. And then if you go backwards to 311, you have, this is the information which is coming up from the compliance team. This is Mary Franklin's email, which is, and you see, 2/3 of the way down, in general, in all cases, the conditions in respect to the Smallwood decisions have been met. And then she just lists these 7 factors. And we say that that's completely inadequate to found a decision that Perm is in the UK. But what we, more importantly, when we come to the question of fact, what we say and what the Court of Appeal accepted was that here you have a clear misdirection as to what the principles or reasoning in the relevant judicial decision was laid down. And so prima facie, looking at, and Lord Justice Newey took this view, they approached this decision that it was the inevitable consequence of the scheme that that Perm was in the UK, and therefore they looked at some very crude markers for it, applying the simplex test, which is summarized in Plan B Earth, you can't say that, that if they'd applied the correct test, there might not have been a different outcome. So that's why, subject to section 31(2)(a), the decision should be quashed. Similarly, on the decision of the degree of confidence that they needed to have. Again, a misdirection which could make a relevant a difference to the outcome. I'm sorry, Lord Stephens.
Of those factors on page 311, which are the ones that do not apply in this case?
D and E.
Sorry, in relation to D, certainly you could take a view on the documents, I suppose, because the orchestration has been documented. But E and F, if your client is believed or your witnesses are believed, then it may not have been for a temporary period only.
Yeah.
If they're believed.
Yes, yes. But secondly, the point here is there was no evidence from the revenue that this was the view that they took of our facts. All they had, all there was Mr. Smith's tick against 9 documents. That was it. And when you're applying 31(2)(a), the critical thing is that the court, but prima facie, if you find an error of law which is potentially material to the decision, you quash it. It's then the court then isn't there to make its decision itself. It's got to look in asking whether it's highly likely that the outcome for the applicant would not have been substantially different. You have to look at the decision-making process of the decision maker. And what you have to look at is what evidence there was of the view taken by the revenue. And the only evidence before the court of what the view the revenue took was Miss Tilling's evidence, and which is I don't know what the actual conclusion made by Mr. Smith was, but I wouldn't have put it forward for submission unless I'd been told that the hallmarks have been satisfied. That's it. What the learned judge did, and we say that's not permissible under a section 31(2)(a) inquiry, is go off and make his own findings by reference to documents. And again, my learned friend obviously seeks to up the significance of the judge's background narrative, but it was basically, he picked 1 or 2 documents out of 260. He didn't pay any attention to the draft witness statements, and he didn't. The witness statements filed by on behalf of the applicant were equally unchallenged, but he didn't pay any attention to those. So when you get to the section 31(2)(a) exercise, the burden was on the revenue to show that their decision-making process meant that if they'd actually directed themselves correctly, it was highly likely they would have come to the same conclusion. But the only evidence as to the decision-making process and what they had the decision they had made was Miss Tilling's, and which was inadequate to satisfy that test. And yes, I mean, just for your notes, this is paragraph 273 of Plan B Earth. And I do accept that the Supreme Court found that the Secretary of State had actually paid sufficient regard to the Paris Agreement. So what is here is strictly obiter, but the Supreme Court didn't perform the Section 31(2)A exercise because it didn't need to. But at paragraph 273 of the report, this is what they said in relation to Section 31(2)A. It would not be appropriate.
Can I have a page number?
Sorry, 1512, 1512. I'm sorry.
Thank you.
It would not be appropriate to give any exhaustive guidance on how these provisions should be applied. Much will depend on particular facts before the court. Nevertheless, it seems to us that the court should still bear in mind that Parliament has not altered the fundamental relationships between the courts and the executive. In particular, courts should still be cautious about straying, even subconsciously, into the forbidden territory of assessing the merits of a public decision by way of judicial review. If there's been an error of law, for example, in the approach the executive has taken to its decision making, it will often be difficult or impossible for a court to conclude that it is highly likely that the outcome would not have been substantially different if the executive had gone about the decision making in accordance with law. The court should also not lose sight of their fundamental function, which is to maintain the rule of law. Furthermore, although there is undoubtedly a difference between the old simplex test, which they summarize in paragraphs earlier, the new statutory test and the new statutory test under Section 31(2)A, the threshold remains a high one, and they cite Justice Sales. And so they quashed the National Airport Plan on that basis. But the fundamental thing is you go back to the decision making of the process and what they actually found. You don't impute. Court doesn't make up its own mind about what they would have found if put in the same position. They carry out an objective assessment of the decision-making process. And so, again, in the case of, I'm leaping ahead, but if you go to gather call, which is in our case, that is the situation. That's the new school near the Lakenheath Air Base. The complaint was made that in the planning authority, in giving permission for a school to be built on a site, it failed to give adequate consideration to the public sector equality duty, and that the outside areas of the school, the noise might be particularly injurious to people with children with protected characteristics. The Court of Appeal refused to quash the. They found that there had been inadequate consideration, but they applying 31(2)A, they said the outcome for the applicant would have been substantially the same, because when you actually looked at the planning officer's report, in other words, the decision maker, the body of evidence before the on which the decision was made, it was clear that the wherever you put a school in Lakenheath, there was going to be noise because of the Air Force Base. And as the Court of Appeal said, you can't wish away that point. And in fact, the design of the building gave it better insulation than the existing school. So even if they had turned their mind to the protected characteristics, the impact on children with protected characteristics, they would have come to the same conclusion because they'd already looked at that. They'd looked at alternative sites, and they actually had, the planning officer said, we've actually, this area is in a lower, relatively low noise area. That's completely different from this situation, where all you know about the view taken of the facts by the revenue in issuing this this following notice is Mr. Smith's review. And I mean, and when Section 3128 is raised for the first time in relation to this issue before this court, we make the point that it shouldn't be allowed, because if it wasn't an issue relied upon before the admin court, we've given you the references to their detailed grounds of resistance and the skeleton argument and the respondent's notice to the court, in the Court of Appeal. It's clear that they didn't rely on Section 3128. The reason is obvious. They'd issued many follow notices on the basis that they hadn't misunderstood Smallwood. They weren't going to start saying, well, we got it wrong, but it didn't make any difference in this particular case. And so everything was on whether there'd been a misdirection. Now, and so the only question of fact really before the admin court was, had there been a review and had it reached a conclusion? That was the question of fact, apart from had they misdirected themselves. And so the revenue say, well, the judge made all these findings of fact. The judge made these findings of fact by reference to looking at a selection of documents which didn't reflect the view of the facts taken by the revenue in issuing the follow notice. The only evidence as to what view of the facts they took in issuing the follow notice and deciding that the principles were determinative was Mr. Smith's review. And
Sorry, Mr. Goodfellow, to interrupt you, but I'm having difficulty following exactly what submission you're making to us. I can understand one point I think you're making, which is that on this particular complaint about the misdirection as to what first should have been applied, the revenue didn't take a point on Section 31. They shouldn't be allowed to now.
Yes. But
you also seem to be making another argument that there were some things that were intrinsically wrong about Sir Ross Cranston's decision on the point that he did decide, which is that although even if there hadn't been an adequate, even if there wasn't an inadequate review, had there been an adequate review, it's highly likely they would have come to the same result.
yeah,
But you seem to be saying, well, that is something a judge can't do. I don't. I'm great to be following that.
What he was, his finding in relation to in 104 to 106 was simply if the review had been concluded on the assumption that there was no misdirection as to the hallmarks and that and to the test, that it was sufficient for them just to look at any document and say, oh, well, that looks like evidence of hallmark number 1 or number 4 or something like that, then it would have come to the same conclusion. He wasn't deciding in any way that even if they directed themselves properly to what Smallwood decided, they would have come to the same conclusion. He wasn't asked to carry out that function in relation to the misdirections. It was solely in relation to ground 3A, which was the unauthorized delegation, and that there was no conclusion reached by Mr. Smith. That was the only, and there wasn't a factual inquiry and about how, if they'd acted on a proper direction, did their decision making mean that the misdirection would have made no difference? It just wasn't a matter. So the judge isn't carrying out a section 31(2)A inquiry in relation to the misdirection, because it wasn't an issue before him. But it's now being raised and saying, oh, look at 104(1) to 106, and he would have found the same way. Well, two things are wrong. He was only, with that view, is one, he was looking at that on the assumption that there was no misdirection. And secondly, looking at applying the principles in Goring and in Gathercole, the function of the court, once it's seen an error of law, isn't then to go and make its own findings of fact. It's to look at what was the decision of the tribunal, of the decision maker, and can you say that it's highly likely that even if you posit no misdirection, you're going to come to the same, it's highly likely they would have come to the same conclusion.
So if you're saying that has to be based entirely on evidence what the decision maker did, and the judge can't take account of a view about what a decision maker would reasonably have concluded, then I can't accept that submission.
Well,
the two are interrelated. I mean, you have to take a view of the whole.
Well, again, this comes back to just if I can deal with that. First of all, Goring and Gathercole and what the Court of Appeal said in Plan B Earth would suggest that's not correct. But it comes back to the unfairness of allowing the revenue to raise 31(2)A in relation to the misdirection now. If their case before the admin court had been, even if we misdirected, we overstated the decisive nature of Smallwood, and that really it ultimately comes down to where the high level management decisions are coming down, then Miss Tilling, we would have cross-examined Miss Tilling or whoever they put up to say they would have come to the same conclusion notwithstanding the misdirection. If you look at Miss Tilling's evidence, which is in the bundle, it was no more. She couldn't give any evidence as to what the conclusion was. There's no written record of it. She can't remember discussing it, etc. All she could say is, I wouldn't have put it forward unless I was satisfied that the 7 hallmarks had been ticked. But what was the point of cross-examining her on that? Well, of course, with retrospect, I would have liked to, but it wasn't the whole focus of the case. Was, had there been a misdirection? Nobody was saying it doesn't matter whether there was a misdirection, as you've alleged. we would have come to the same conclusion. In which case, the actual view of the revenue would have been absolutely much more front and center, central to the debate. And the focus, it wouldn't have been a 3-day hearing before the admin board, in a 6 or 7-day hearing. ABC would have had to gone into the facts, but that's why it's so unfair to allow the revenue to raise this point now. So if I can take just very briefly to page 274 and following. This is in relation to the 31(2)(a) point. So we say it's unfair to raise it now because if it had been raised earlier, it would the hearing before the admin court would have followed a different course. And the Notting Hill case, which is cited, is relied upon for that proposition. Secondly, Lord Justice New was right that the passage of Mr. Justice Cranston's decision solely related to what would have happened if a review using the hallmarks had come to a conclusion. It wasn't what would have happened if they'd directed themselves properly. And thirdly, when you look at the Tilling evidence, you can't say on the basis of that evidence as to what view they took, it's highly likely they would have come to the same conclusion. It was completely inadequate material. And fourthly, the findings of fact relied upon go well beyond anything the revenue had put in evidence as to the view they took of the facts. And if you can look at very, very briefly the revenue, this is Mr. Smith's review, and Ms. Tilling's evidence was that he carried out the review. This is so that's page 274 of the bundle onwards. And do you see on the right-hand column? Sorry, if you turn it this way up, so to speak, you'll see in the right-hand column WFG conditions for follower notice. And basically you have a list of all the documents in the revenue's possession. And let's say against document, the first document, this is regarded as being evidence of point 3, that the tax planning discussed in the UK, devised in the UK. So what's said to be evidence of that is a settlement deed between Mr. Haworth and UK resident trustees in 1988. This is meant to be evidence of a tax planning scheme arrangement put in place in 2000. And literally, if you just go through there were 260 documents, and there were 9 points of places where he says point 3, point 5, point 7, and you can go down the page. Page 278, you have another one, point 4. This is a deed of facts in respect from the Haworth number 2 settlement, enclosing a deed of appointment, appointing funds from one settlement to another settlement. So from a UK solicitor. So what you have is a UK solicitor providing a draft deed of appointment in relation to an English proper law trust. And that is meant to be evidence of usurpation of high-level decision-making. And we come to an end. It just goes down to an end. You have no document by Mr. Smith saying, I conclude X, that the high-level decision-making to sell these, to enter into the merger on these terms, to float the company, and for the trustees to sell the shares, they were all made in the UK. There's nothing along those lines. So, completely, and again, if you look at paragraph 105 of the judge's decision making, if you just do you see at paragraph 105? He speaks of the evidence set out at length above, but in particular, there was Maslin's evidence letter of 24th of April with counsel's advice. He lists various documents. None of those documents was the subject of any comment by Mr. Smith. What view Mr. Smith took of those documents, what they indicated, it remains a complete mystery. If it's said that Mr. Justice Cranston was performing a Section 31(2)A exercise in relation to the effect of the misdirection, he was clearly not following the guidance in Goring and Gathercole. He was making those decisions himself. And it was not based on evidence. He was just looking at various documents. There was no and again, just as we made the point in our case, when you're looking at the inadequacy of the review carried out by Mr. Smith, which is what you've got to do once you're in 31(2)A territory, and we're in no way precluded from making these submissions if, contrary to our prior submission, this point is now allowed to be raised. If you look at page 283, you have under that the middle column, if you see the statement of Mr. Gujadur, he's the Mauritian trustee. Do you have that? And then you have the statement of Geoffrey Richard Haworth. And again, these statements prepared in 2006 were before the revenue, but there's absolutely no comment by Mr. Smith about this evidence. It's not, this is untrue, don't believe him, etc. It just isn't the subject of any review at all. So it really isn't possible for this court to say, well, look, we can see what they've decided, and we can see that they, even if they direct themselves properly, it's highly likely it would have come to the same conclusion. Yes, I mean, paragraph 105 is is an example really of where the judge has completely gone out and started making decisions on his own by reference to a random selection of documents. And again, the judge didn't actually pay any heed to Mr. Gujradul's statements, or Mr. Howard's statement, or the statement from the various solicitors from Bidson and Curtis saying we were providing standard trust advice and trust documentation. We weren't telling people them what to do. So can I realise I've probably got 10 minutes left.
At the most, Mr. Appellant.
So if I can go, I can focus on reasoning principles. We say those are legal reasoning because that's what's going to be decisive of other appeals. We rely on the points made in our statement of case. The second point on the adequacy of the section 206 notice, we'd say it is a matter of looking at the particular statutory scheme to work out the significance of strict compliance with the requirements. The point here is this is not a situation where the recipient is already chargeable or subject to a liability, and he's claiming that because the notice was given late, he should be relieved of that liability, as in rates or in tax or anything like that. This is a situation where the taxpayer is not subject to the penalty. He only becomes subject to the penalty if he fails to take the corrective action in response to the notice within the 90-day period. It's clearly essential that that notice should give him the reasons why the revenue say that the principles or reasoning are determinative of his case. Obviously, and where the Court of Appeal were right to hold that the notice was inadequate, because whilst it set out what test they were applying, partially, they gave absolutely no indication of how they saw those principles applying to Mr. Howard's case. Secondly, they didn't reveal the true basis on which the revenue had made their decision. I've taken you to the document which shows the true basis. They thought it was the PERM in the UK was the inevitable consequence of the scheme. That wasn't in their notice. It was by omission misleading. And thirdly, they claimed to have made a finding that there was a scheme of management, a higher level management being controlled from the UK. There's absolutely no evidence of that. So again, that was misleading. So if you're going to make, it's the unreasonable behaviour of a taxpayer who fails to take corrective action in response to a notice telling him why he's going to lose. It's vital that that notice should be accurate and complete. This notice was neither of those, and it completely undermines the system. You can't make representations, effective representations, if you don't know what the case is against you. you can't effectively challenge them for errors of law if they don't tell you the basis on which they've made the decision. And you have to make these incredibly difficult decisions in ignorance of the case which is going to be made against you. And this is aggravated by the response of Ms. Chalmers to the representations, where again, she didn't say in what way, in what way we were done down by the principles of reasoning in Smallwood, how they applied to our facts. All she said was they're not materially different. And so Mr. Haworth had to take the critical decision not to take the corrective action in the dark about what the revenues case was. And if you look at the balance of advantage and disadvantage by striking down a notice which doesn't give a proper explanation, there's an inadequate, misleading notice is capable of inflicting massive prejudice on the taxpayer. One, by making him give up, pressurizing him to give up when the revenue have made a wrong decision, because they haven't told him about the nature of the basis on which they're making the decision. Alternatively, it doesn't sufficiently explain the impact of the decision, so he doesn't know that he's going to lose, and therefore he exposes himself to the penalty. By contrast, if you strike down the notice because it's inadequate, the revenue have another, they still have 12 months from the date the decision becomes final to issue another one. And in this case, they had 2 years. The fact they left it to the last minute was nothing, no fault of ours, no fault of Mr. Haworth. So again, the whole genesis of this penalty is the unreasonable reaction of the taxpayer to a notice telling him he's going to lose and why. And so that's why the notice should be struck down. The earlier notices or correspondence adverted to by the Court of Appeal in relation to Mr. Haworth, they were in the context, they were in the context, they carried out before the Finance Act 2014 enacted. They weren't purporting to apply the tests in Haworth. Sorry, in the follower notice legislation. They referred to other taxpayers. They applied the findings of fact in this made by the special commissioners, not by, at least in part, not applying the principles or reasoning in the Court of Appeal. So they were completely confused, and they no more than said they were doing no more than saying, well, this is the reason why we think we're going to win. That's not what's required. You need a single document which sets out clearly why the principles or reasoning of the decision are determinative of your case. Sorry, in relation to ground one, cases like the Raymond Begum analysis is completely flawed, because Begum, it was all about predicting the risk of future actions, whereas this is a backward-looking exercise. This is looking at past actions. What are the legal consequences of those actions? Secondly, these raise the follow notice raises legal issues, totally legal issues, not questions of non-justiciable national security issues. Now, whether what is clear is these, given the massive pressure these notices place on taxpayers, they should not be issued lightly. They should be issued where the principles or reasoning show that the tax arrangements are going to fail. Now, whether you put that as, because the reason is there's too great a risk that they are going to be the last word in the dispute, because who can really, how many people are going to run the risk of a 65% penalty
Well,
or
Mr. Goodfellow,
a 50% penalty?
you're very much up against your deadline. I know you've lost a little
Okay.
bit of time this afternoon. but
Okay,
you must-
2 minutes. Whether you put it that way or as suggested, so in other words, the revenue's got to be confident that it's clear that the arrangements are clearly going to lose, or that the content of the decision is these principles are determinative. There are two ways of getting to the same result. Parliament should not be treated as having interfered with the right of access unless the revenue can clearly and confidently say these principles or reasoning things determine that this case has failed. This arrangement will fail. And on either, and it's accepted by my learned friend that they didn't reach that degree of confidence. They just said, well, you know, on balance, it's more likely than not we're going to win.
Thank you.
That's my submission, sir.
Thank you, Mr. Goodfellow. Yes, Mr. Stone, I'm slightly curtailed, but I'm afraid Mr. Goodfellow got a little bit of a late start this afternoon as well.
My lord, may I run on just a couple of minutes after 4 o'clock in that case?
Yeah.
I'm grateful. I have a number of points to run through. The first, a short one, I said to Lord Stevens that I would provide the reference to the witness evidence explaining the inadequacy of HMRC's ability to refuse postponement as a solution to tax avoidance. That's paragraph 9 on page 455, my lord. Lady Arden asked if the outcome in Smallwood was unusual. Oh, because of a number of settlements, only 2 round-the-world cases have gone to the First Tier Tribunal since Smallwood. In both cases, Poem was found to be in the UK. My third point, my learned friend relied upon a report of the House of Lords Committee to make the point about iniquity of the follow notice regime. And my submission, the views even of eminent thinkers about whether the regime is appropriate is not relevant to the questions that this court has to address. Parliament has passed legislation that allows HMRC to give a follow-on notice if certain conditions are satisfied, knowing that they will discourage a certain group of taxpayers from pursuing their appeals to the FTT. And indeed, that was the very purpose of the legislation. There is clearly no proportionality challenge on this appeal to the size of the potential penalty. And the only issue is whether further restrictions that could have been used by Parliament but were not should be read in. And my submission, for all the reasons I said before, they should not. And this is in contrast with Unison. The impact of the fees order in that case went beyond the purpose of the legislation. So one of the purposes was to deter unmeritorious appeals, but the fees order impacted all litigants. But in any event, what does my learned friend get out of Unison? He suggested that because of the reasoning Unison, you should read Section 205 in a way that follow-on notices can be given only to unarguable cases. But there's no warrant for that, and there's clearly not a proper way to construe the legislation. It shows the danger of departing from the words actually used by Parliament. My learned friend said, next point, that follow-on notices are more likely to be issued for mass-marketed schemes, which use identical documentation. Well, I agree. It will be easier in those cases to find that the principles or reasoning would deny the advantage. In a case such as the present, it will require careful consideration to determine whether the reasoning or principles do apply, notwithstanding factual differences. But that is precisely what HMRC did in this case, as evidenced by the fact that follow-on notices were not given in over half of the round-the-world cases reviewed. The follow notice regime, and this deals with the point that Lord Stevens raised with my learned friend. The follow notice regime is clearly capable of application to cases where the taxpayer asserts that there is a factual difference between his case and the lead case. And in that context, and directly in answer to Lord Stevens' question, HMRC can take a view on as to credibility. So if the taxpayer says that the settlor handed over complete control of his multi-million-pound corporate restructuring to a Mauritius trustee that he didn't know, who had no experience of corporate transactions, it will not be that hard to disbelieve him. Similarly, if the witness statement says that the appointment in Mauritius was not temporary, notwithstanding that the documents show that on appointment in June, the Mauritius trustees were anticipating retiring in October, the witness statement will not be believed. All will turn on the particular facts of the particular case, but there is nothing inherent in the regime which prevents HMRC from taking a view on the evidence that it has before it in totality. Lord Stevens, yes.
Did they do so in this case? Did anybody consider credibility?
There was, we don't know. That's a point that Mr. Goodfellow laughs about. But the fact is that the state of the evidence was such that the person who conducted the review is no longer works for the revenue, didn't give a witness statement, and we don't have any emails because they've all been deleted from him. So
the fact that he's retired doesn't mean to say you can't ask him.
No, my lord, that is true. But
was he asked?
I cannot say, my lord. I'm sorry. Yeah. As in, I don't know. But I repeat the point that my Lord Legate made at an early stage in my learned friend submissions, that of course he has no permission to run any appeal based upon the inadequacy of the review that was conducted, or to assert that there wasn't a review conducted in this case. So just as it will be easier to issue follow notices in mass marketed schemes, conversely, for an Edwards and Bairstow type appeal, it may be harder to identify the principles or reasoning that would deny the advantage in another case. But the fact that the conclusion is expressed as merely upholding the FTT, rather than expressly agreeing with it, says nothing about whether there are principles or reasoning which are capable of determining another case. In our written case, we gave the non-tax example of my Lord Legate's recent judgment in Uber. And I'd ask you to consider paragraph 119 of that judgment, which for your, not now, but your notes is of page 1644. In that paragraph, the first sentence is that the employment tribunal were entitled to conclude that the drivers were workers. In the second sentence, Lord Legate says, and indeed that was the only reasonable conclusion. Now, on the respondent's case, with that final sentence, and because of the final sentence, the judgment is capable of having principles and reasoning that could determine another case. But without that sentence, there could be no principles or reasoning in that careful judgment. That, in my submission, cannot be a correct distinction. It all depends on the content of the judgment, not on the form with which the conclusion is expressed. My Lord Legate asked during my initial submissions what we should make of the word would. My learned friend says in his written case that it means will, but by itself that change in my submission achieves nothing, and it brings you back to the degree of confidence that HMRC must have in the outcome. Parliament could certainly have said will certainly deny the tax advantage, or some variation, but did not do so. In my submission, the statutory language is clear. HMRC must form an opinion about what would happen if the reasoning and principles were applied, and if, having evaluated the case before them and the reasoning and the principles, HMRC reaches a conclusion that those principles and reasoning are determinative, then the statutory condition is satisfied. And that's why you can't read would by itself without taking into account that the opening words are that HMRC is of the opinion that.
If it is the case that the decision in the ruling which is relied upon by HMRC is ambiguous and needs serious argument, could it not be said that HMRC should not be treating it as precedential status for the purpose of follower notices, because we simply get satellite litigation involving the court in having to deal with a decision, not in the usual way when it arises in the context of some other appeal, but in the base on as a side issue in the judicial review proceeding.
My lady, you're entirely correct to say that we should be avoiding satellite litigation about such points. But my answer to that point is that it is Parliament who has given HMRC the primary responsibility for reaching an opinion. There may well be differences of legal opinion as to precisely what was said in a case. I may say it's absolutely clear that Lord Justice Hughes was rejecting the concept of usurpation in those paragraphs in Smallwood. My own friend might say to his blue in the face that he was finding usurpation. But Parliament gave the responsibility to HMRC in the first instance to form an opinion about the principles and reasoning and how they would determine a case. If HMRC do so on a case that is properly ambiguous, then there would be good grounds for challenge by appeal by the taxpayer. HMRC in my submission wouldn't do that. I mean, you have nothing but what I say in my word, but it would not be HMRC's policy certainly to use ambiguous decisions to issue follow notices. But if, as I say, the protection for the taxpayer in this case is the right to appeal, either on the grounds that the lead case is not relevant to its chosen arrangements, because, for example, there are no principles or reasoning, or to appeal on the basis that it was reasonable for him not to take the corrective action because he was advised that he didn't need to do so in that situation.
Well, it seems to me provisionally, and I'm speaking only for myself, highly unsatisfactory that in a case where the HMRC itself had difficulty in understanding what was decided in Smallwood, and where we have two distinguished counsel experts in the field telling us it says different things, and it's a very brief report, in a very brief judgment in issue, that it should be possible for HMRC to issue follow-on notices which require the taxpayer to take the initiative to appeal, and where the court may find itself having to decide what was decided, not in another tax appeal, but in this judicial review.
Yeah, but I can't take the submission much further, my lady.
It may be that's one case which was outside what Parliament had in mind.
But in my submission, my lady, that there is no ambiguity or uncertainty about what Smallwood actually decides, and that what the judge decided in this case was the principles and reasoning in paragraphs 86 and 87 of his judgment was entirely accurate. They are the principles and reasoning which he found HMRC had applied. This goes back to the first point you made. Yes, there was some mangling of language in some of the internal documents, but ultimately it was appreciated in the paragraphs I showed you that Poem was a finding of fact by the special commissioners, and that Lord Justice Hughes found they were entitled to do so, and Mr. Justice Cranston found that HMRC had properly applied those principles and reasoning.
Yes, but if the aim of the legislation on follow-on notices is to reduce the resource burden for the FTT, if the HMRC bases its decisions on highly contentious decisions, there's bound to be quite a lot of satellite litigation, but that may be just an observation.
We're running quite late on time, but I think we must give Mr. Stone the chance to finish his reply. Yes,
my lord, I'm grateful. Though on ground 3, which is the section 31(2)(a) point, I can be relatively will be brief. It's not a new point. You can see from paragraph 46 of Lord Justice Newey's judgment that he was applying section 31(2)(a). He was required to do it. Section 31(2)(a) is in mandatory terms. You have it in the bundle at page 779. In contrast with section 31(3)(c), which applies on an application for permission to appeal, when the court may consider it of its own volition and only must do it if the point is taken by the defendant. So it's not really a question of a new point at all. Lord Justice Newey was, we say, incorrect in his application of the section because he departed from the judge's findings. At paragraphs 104 to 106, the judge had applied section 31(2)(a). Yes, it was in response to a different alleged error in the decision-making process, but his analysis, based on all of the review documents and the scheme documents and the correct understanding of Smallwood, was that it was very likely HMRC would reach that opinion, that Smallwood was relevant. That is precisely what would have happened, therefore, without any alleged error of understanding of Smallwood. And that exercise was open to him. In paragraph 61, we cite file written case from Goring-on-Thames, where it said the court must necessarily undertake its own objective assessment of the decision-making process and what its results would have been in the decision, if the decision maker had not erred in law. Well, if there hadn't been an error of law in misunderstanding Smallwood, then the conclusion that would have been reached on the decision and making process is the one that he reached at paragraph 106. And he didn't reach that conclusion on a random selection of documents. All of the other side's witness statements were in the documents that were before him. He reached his conclusion on the evidence he saw when the submissions were made to him. And very final point on section 206 and the quashing of the follower notice. The statutory requirement is to explain why HMRC considers that the ruling meets the requirements of section 2053. The statutory requirement is not to explain how HMRC came to that conclusion. And the Court of Appeal did not find that the follower notice was in any way misleading or failed to comply with section 206 because it didn't explain the basis of the decision. There's no dispute that the two-stage test in SM Rwanda taken from Honda Motors is appropriate. The respondent's case is that at the first stage, the Court of Appeal was wrong to say the failures to comply with section 206 can be minor and inconsequential because only material failures to provide an explanation will fail to satisfy the statutory requirement. But that argument is circular and incorrect. There can be a failure to provide an explanation which has no consequence for the taxpayer because he already knows in detail why HMRC hold the opinion they do, that the judicial ruling is relevant, such that it makes no difference to him if it is set out in the follower notice itself. And that is precisely the position that averted here. My Lord, those are my submissions.
Sorry you had to go at a bit of a canter. Well, thank you both for some very... I can see someone's hand up. Mr. Goodfellow?
Yes, my Lord. Just draw the Court's attention to section 31(2)(a). It's the power is vested in the High Court.
Thank you. We'll consider that, Mr. Goodfellow. I was just saying thank you both for your helpful and well-prepared submissions, and indeed, please pass on our gratitude to your teams as well. Meanwhile, we will consider what we've heard and let you know our conclusion due course.